So this is the first in a series of why the internet is wrong. Today the internet is wrong because of the Candy Crush Saga, Trademark Saga, TM. So my name's Nicholas Hall. I'm an attorney based in South Africa. I'm the chairperson of Make Games South Africa, an industry association that represents game developers. You can find me on the Make Games South Africa forums as Lexiquilia. You can also find me on Twitter as @NickHallSA. So, I'm sure most of you probably know what's going on, but for those of you who don't, a couple of days ago, King, the company that owns Candy Crush Saga, purportedly filed or has filed for a trademark of the word candy and the word saga. Then they went on and sued the Banner Saga, or rather Stoic, the people behind the Banner Saga. This made the internet very, very angry. There was so much rage, Twitter exploded. I just remember they even started a game jam called Candy Jam, where people were encouraged to make as many games as possible that infringed on the supposed trademarks. And the reason why I'm angry about this, and why I think the internet is wrong, is because a lot of people, I think, are misinformed or don't understand what's actually happened. So what do we actually know? Well, first off, King hasn't actually trademarked anything. Secondly, they haven't actually sued anybody either. They haven't prevented Stoic from making the Banner Saga or even forcing them to change their name. But why are people so angry? Well, a lot of people are angry, at least this is what by analysing the themes, this is what I've come to, is that they shouldn't be able to trademark a simple word like candy that's nondescript and is used in every day. Other people are angry because they're bullying smaller studios, or they claim that King, a big multi-million company, is bullying a smaller studio. Others claim that they're abusing the legal system to their own ends. And I think for the majority of people, they're just shouting and being angry because everyone else is. Before we can really analyze why the internet is wrong, though, I think it's important to go through a very brief analysis of what a trademark actually is. So the first thing that's really important to point out is that trademarks aren't monopoly rights. This means that you can't, just because you have a trademark, you can't force other people from using whatever that trademark is. So just because they've got the candy trademark doesn't mean they can prevent other people from using the word candy in their games and other products. It doesn't work like that. The second thing, which is also really important to consider, is that a trademark isn't global. Just because you have a trademark in the United States doesn't mean that you have a trademark in Europe. It doesn't mean that you have a trademark in Africa. So just because they filed for a trademark, and they filed for a trademark in the US, and they've bought a trademark in the UK, which is applicable in Europe, doesn't mean that they can enforce this as a trademark worldwide. The second issue is, what does a trademark actually protect? The big thing is it can protect one of two things. Mostly it protects logos. So we're talking about like the BMW shield, the Nike swoosh. The other thing that a trademark can protect is the actual text, so an actual word. This isn't to be confused though, because sometimes logos contain the words, and that's a separate application. That would fall under the logo, not the text. So the other thing to consider then as well is that trademarks, you don't just have a trademark for something over a word or a logo. That has to be registered in what's called a class. So for example, in South Africa we have 39 classes which represent different industries and different uses. So Candy Crush, or rather King, have registered the trademark Candy and Saga, or attempting to do this at least, in very specific classes. It doesn't mean that they're going to be able to sue candy manufacturers for trademark infringement. It doesn't mean that they're going to be able to sue car manufacturers, for example, only in the specific classes. And then lastly, and this makes me particularly irate, is that people are conflating or confusing trademarks and copyright. Trademarks are not copyright. They are completely different things and have completely different sets of rules. One of the most important things being copyright is a monopoly right, but this is not the issue. Angry. Okay, the other thing that's important in terms of the actual games industry, though, is that we've been here all before. One of the first cases was, one of that most people may spring to mind, was when Games Workshop sued an author for the use of the word Space Marine in an ebook that she published. Again, though, I think the story has been misrepresented, because what actually happened? Well, they didn't actually sue her. They didn't sue her for trademark infringement. What they did do was report her to Amazon for trademark infringement, and Amazon took down the book. But then, because Amazon has a decent IP policy, they reviewed the complaint, decided that it didn't apply because it made sense, and they put the book back up. Another one was when Bethesda tries to sue Mahjong for the use of scrolls from Bethesda's The Elder Scrolls series and Mahjong's upcoming game Scrolls. Again, people seem to think there was a massive misrepresentation here. It got settled out of court, no one sued anybody. Again, all there was an objection to them filing the trademark. But the most important case, and I think which goes to the heart of the matter and why the big companies are behaving like they do, can be found and crystallized in the Edge case. There was a case in the UK where a man owned a company called Edge Games. He asserted that he had the common law trademark over the word edge, and this is important because it bears into a lot of other things. Let's talk a difference between common law trademarks and registered trademark. If you see something with the word TM next to it, it means that it hasn't been registered. If it has a circle with an R in it, that means that it's registered. The only difference is that it's from a judge's point of view, so when it comes down to evidence. Anybody can assert a common law trademark over any brand or slogan that they use on a day-to-day basis. But if you haven't registered the trademark, it means that when you try to enforce that, you have to go and prove that you have established use. By registering the trademark, you can skip that process because you have a certificate saying, look, judge, I own this trademark, and those people are using something that looks very similar to mine, and that you should stop them. Anyway, he claimed that he had a common law trademark on the word edge. He then tried to sue a magazine called Edge Magazine that was also reporting on the games industry. They didn't actually go to court and they settled, but he then proceeded to go and sue everybody. He was versed the world. Eventually someone called him on his bluff and actually went to court, and he was found out to be a very naughty boy. It turns out that he had falsified a whole lot of evidence and that he didn't really have a claim to the trademark in the first place. But one of the reasons that the judge found was that he wasn't active prior to these cases seeming to be enforcing his trademark. And I think this is important because of precedent now. Companies see this as a fact, and it isn't just from the Edge case, it's actually established trademark law that if you have a trademark, you have to be seen to be actively using it and defending it, preventing others from using it where it could affect your brand in order to enforce it. So in the Games Workshop case, in the Bethesda case, and in the Edge case, which is different but wrong, a lot of the time companies have been acting the way they've been acting to be shown that they have been trying to enforce their mark, even if they don't really have any issue with the mark instead. But if they don't, they're worried that should they have a legitimate reason to try and enforce their marks, this will be used against them as evidence that they shouldn't be able to use their trademark. Okay, so let's deal with those arguments that people have one by one. The first is they shouldn't be able to trademark everyday nondescript words. They can. It happens all the time. Think about things like Sun from Sun Microsystems. Think about Windows. Think about Apple. Yes, I realize that it's a bit different because these are the names of actual companies or brands, and this isn't as opposed to Candy Crush Saga, where they've just decided to try and trademark just the candy and the Saga part. But the point is that by virtue of the fact that it is a nondescript everyday word doesn't mean that it cannot be trademarked. Normally there are special implications because you have to be able to show that it's tied significantly to your brand, but by virtue of the fact that it's a nondescript word, it doesn't matter. Okay, they're bullying smaller studios. Here's the thing. Stoic didn't really need to do anything. What happened, if we're going back to the case, is like we said, is King doesn't actually have any of the trademarks. They've purchased the candy trademark from somebody else. Why didn't people get angry then? Why didn't people object then? That some other game studio, some other company had registered the word trademark in the electronic entertainment category. Who knows? But they've only filed for Candy and Saga in the US and Europe as well. They don't actually own this trademark, and all they've done to Stoic has tried to register the trademark Banner Saga, which they're entitled to do. King is entitled, they have a right to be able to object to this, so they can be seen to be trying to defend their existing common law or registered trademark rights. So when they do go after the cloners, they can't use the fact that the Banner Saga is against evidence. What will likely happen, what probably would have happened if Stoic's lawyers didn't have to step in, was that the trademark office would see quite clearly that these two things are completely different, and that there's no way that they could be confused in the common fact, and it would have gone to nothing. And the internet could have spared that hate onto something more useful. It's abusing the system. No, it's not. It's using the system exactly as the way it's designed to be. If you're going to register a trademark, people should be entitled to defend it. In South Africa, we have a 3-year-long process where this happens. They're just using it as what to do. It's okay. They're not abusing anything. Okay, who should you be angry with? You should be angry with the lawyers, because they're the ones who fucked up here. Am I allowed to swear? There are ways to handle IP litigation issues. I don't think it would have been out of line. King has admitted that they realize that the Banner Saga is not a clone of their game, that there's no way that the people could be confused with. The one has big beefy Vikings, for Christ's sake, and the other one's about little candies. What they could have done, though, is extended a courtesy towards Stoic, informed them that they were going to be objecting to power, and I'm sure something like a coexistence agreement could have been entered into. Coexistence agreement is when two companies who have similar trademarks decide that they're not going to litigate over the matter, and rather they can coexist peacefully, like friends. So here's my word to game makers. If you get a threatening letter claiming that you're infringed someone's trademark, just chill. Take a breath, make some games. It's probably not as bad as you think it is, and will be blown over in a while. And then give me a call. If there's something real, you deal with it.